Hello, everybody. We're going to take a look at a recent AI case that was brought to my attention by Robert Freund, who some of you may recognize from Twitter. I'll show you his profile real quick. I don't know if you guys can see that very well, but it's right here. Specifically, it is this post from, let me see, I think it was a few days ago, about 2 weeks ago. Ninth Circuit case, immigration case, and rather than tell you what happens, I'll just go ahead and show you. One thing that you should know going into this, and it'll be discussed in the video itself, is that the parties did not request oral argument. The judges set it for oral argument themselves, and that is going to explain a little bit of the tension that you see here, because that's unusual. Usually if the parties don't ask for oral argument, you won't have oral argument. So there is that kind of question hanging in the air. So without further ado, let's go ahead.
Good morning, Your Honors. May it please the Court, William Rounds on behalf of the petitioners, Malkeet LNU and family. I would like to reserve 2 minutes for rebuttal at the end, so I'll try and keep track of my time. Now, this case is primarily about the BIA and the immigration judge failing to consider all of the relevant factors in making an adverse credibility finding, and ultimately in their
that means that the judge didn't believe the petitioner, but in lawyer speak.
Determination to deny asylum, withholding, and convention against torture. Both either misrepresented the record or failed to address directly relevant facts that would undermine the adverse credibility determination that the immigration judge made. First, and probably the most clear, the BIA misrepresented the fact that the immigration judge did invoke the falsus in uno maxim. The BIA stated that the judge did not invoke it, but the immigration judge.
That maxim means that if you don't believe one thing that a witness says, or if they say one thing that is false, you can discredit everything that they say. You don't have to, but you can.
Quoted the falsus in uno maxim. The immigration judge cited to a case where he got the falsus in uno maxim, and that was one of only 4 cases total that the immigration judge cited in his oral decision. Now, he included a separate addendum of law that had several other cases, but in his oral decision, there was only 4 cases cited, and that one, referring to the falsus in uno maxim, was one of them. So for the BIA to state that the immigration judge did not invoke the falsus in uno maxim, I think is just a clear misrepresentation of the record, and that's a clear indication that the BIA did not consider all of the relevant factors when coming to its...
What was wrong with invoking falsus in uno?
There's nothing necessarily wrong with invoking it.
How about in this case?
In this case, there is nothing wrong with invoking it at all, or in general. It's the fact that the BIA stated that the immigration judge did not invoke it, when it's clear on the face of the judge's decision that it was invoked. Now, the falsus in uno maxim is can be used to say, hey, there is a problem or something, some inconsistency, some discrepancy here, and so I think we should apply it elsewhere. There's nothing wrong with doing that. But the way that the immigration judge did it and the fact that the BIA claimed that it was not invoked is the issue.
Why is that a problem? If we agree with you that the immigration judge did actually invoke it, which I think that's a disputed question, but if we agree with you, why is that an error for the BIA to say that it didn't happen?
Because it's plain on its face that it didn't happen. So if the BIA is going to make that kind of an error I'm trying to get at material. That's sort of a procedural point, but what does it mean in terms of the substance of the decision? It indicates that if they did not notice that glaring error, that there may be other errors that they did not notice.
So nothing about that in and of itself is
philosophical.
problematic in terms of reviewing the merits of this decision?
Well, I think that there's other issues.
Yeah, I mean, I think that he has a point that if there was a mistake made in one area, there could have been a mistake made in another area. but your argument would be better off if you could point to those other mistakes, especially since it's on appeal and you have presumably a fairly well-developed record.
Because many of the specific issues or the specific discrepancies or inconsistencies that were raised themselves can be significantly undermined. And so I don't think that there's any material discrepancy.
Well, the IJ did go through each of the alleged deficiencies in his credibility.
He did, and there's many of them that I think are undermined because...
So why don't we just look directly at what he did rather than worry about the...
Certainly. So I think... and we can do that. One of the main issues was that they found that there were errors in the documents, and so the sufficiency of the documents was not such that it could be that the documents submitted in support could be reliable or credible. For example, the statements, the affidavits of the petitioner's father and the village elder, the Sarpanch, both of them included the same phrase. They said, "My son Malkit." Now, looking at the totality of the circumstances of both statements, that's clearly nothing more than a drafting error. Both of them contain boilerplate-type language. The introductory 2 paragraphs are things like stating who they are, the fact that they have personal knowledge of what they're testifying to, their relationship to the different parties involved. That's fairly boilerplate language. However, the rest of their statements are a mix of similar language but also unique language, because both of them, the father and the Sarpanch, are testifying to events that both of them saw from their own perspectives. So there would be some overlap, but there also is some unique language.
Isn't the official's statement in the affidavit that he was quoting the father? I mean, so you don't have to go that far. It's just an error because he was actually quoting somebody else, wasn't he?
In that particular case, there's a lot of quoting back and forth of each other, but it just looks like it's a simple drafting error when looked in the totality of the
when
circumstances.
I looked at it, it said, let's see, Jarnal Singh, he was the leader?
Correct.
Right? Okay. So the way I read this, he says, knowing the police is not going to help my son Malkit, and there's a word left out, other option left but to leave from India with his family. His father, Ram Kalan, told me on December 15th, 2022 at the market. Now, that was raised to the BIA. I mean, they raised that. They pointed that out, that discrepancy.
It was, and I think...
So the last part, just sort of gets dropped out by the IJ and by the BIA.
And I think that another issue that the BIA makes, or problem that the BIA makes with their decision, is that they...
I'm just leaving this in for background, but just so you know, the AI part is coming up in just a minute.
Talk about that phrase, that statement going to the core issue or a core issue of the case, which it's not really a core issue. It's simply kind of a generalized closing statement of their intentions. It's not establishing any particular fact that either of those individuals saw or witnessed. And so I think that one particular discrepancy is either minor, not going to the heart of it, which would give it less weight, or is in a totality of the circumstances just obviously a drafting error. Another issue that the judge and the BIA both had was with the distinction between whether Malkit was a member of his political party or whether he was a worker in his political party. Now, on his asylum application on page 5, in response to a question, he wrote that he was a volunteer member of the party. On the next page, on page 6 of his application, it says that he was a worker for the party. Now, in all of his testimony and all of the other documentation, it's pretty consistent and clear that he was a worker for the party, and his testimony makes that clear that that's important. But when the immigration judge mentioned and said that this is an important distinction, and he put it wrong on his asylum application, the judge did not mention that on the very next page, on page 6, he said that he was a worker. The judge also didn't mention that he had included the word volunteer before member, giving it that qualifier, that it's not your regular typical member, that he was a volunteer member. So again, it appears that a drafting error, something that was maybe not the most clear language, is being used as something that is more significant than it is to find that the petitioner and his documentation is not sufficiently credible. Now, when the judge asked the petitioner on the record about this discrepancy, it's obvious that he did not know what the discrepancy or that the discrepancy existed. He just was the result of oversight or something like that. So again, the immigration judge and then the BIA to uphold it took a very minor error and blew it out of proportion, but did not mention and did not note the substantial facts that would have undermined their adverse credibility finding.
Counsel, I want to shift gears a minute.
Oh, here we go.
Recently, on behalf of your client, a document was filed indicating that there were errors in the briefing that was submitted, and asserting that they were typographical errors. I'd like you to address that point and how they occurred.
Yes. So there were two cases. The case names and the citations were somewhat garbled. On one, the case name that was cited in the brief was Eduardo, but the correct name should have been Udo. It stands for the same proposition. There's no difference in what the case stood for. And where the error came from, not sure. It looks like it was a copy and paste error or something like that.
Wasn't it the use of artificial intelligence?
It was not used.
Because you quote from...
Okay, one thing to note, this will become relevant in a second. Notice that he affirmatively states it was not used, not I don't know. He is saying straight up, AI was not used.
Malthus versus INS, the phrase, an adverse credibility determination is not necessarily a death knell to cat protection. And my clerk took a look at that case, and so did I, and we couldn't find that phrase anywhere. It just made up.
I think that phrase comes from a different case.
Man, Control F is really tough for these AI cases because it's pretty easy to find out whether something doesn't exist.
I think Shrestha, another case that was cited, does use that phrase.
But your brief gives it to the Malthus case. So are you sure? Are you telling me the truth that you didn't use AI to beef up your brief here?
No, AI was not used to beef up the brief.
You've been given an out. Just take it. Like, and this is a thing that people don't seem to realize about AI cases, is you've already been caught because they already know that you made up the quotations and that you messed up those citations. So even if you didn't use it, like, you've already been caught. It's just a question of whether you're going to come clean about it or not.
That phrase.
In also the case of Avedano, Hernandez versus Lynch, the phrase, the BIA must consider all evidence of record, including evidence of country conditions in assessing the possibility of future torture, is a hallucinatory phrase. It doesn't occur in that case.
I don't think that's an exact quote. That is discussing what the overall case stands for.
Stick with the quote. Did you use AI in using that quote, counsel?
Third chance to own up to it.
No.
3 strikes.
Who actually...
Then how did it get there?
So
Answer Judge Bay's question.
An individual who works at the office drafts briefs, prepares them.
Maybe the individual. Did the individual use AI and report it to you?
It is possible, but that person did not. That person did not indicate that they used AI.
Is this person in the room with us right now?
And there had been many
Counsel,
conversations.
we're having a hard time believing that because of our review of this case, but we also looked at other cases from your office, and there are other cases that briefs have been filed that are currently pending in this court that have same problem. And this doesn't look...
Oof. Man, they're doing research on your ass. You're in trouble. I'm in danger.
Like a typographical error. It doesn't look like a copy and paste job. It looks like there is a use of technology being employed that is not being checked.
There had been many conversations with that individual who was drafting to verify that AI was not being used.
Okay, but did you check the the cases? Because that's a really easy way to verify.
And that individual said that AI was not being used to draft the briefs. And that had been repeated many
How
times.
could you have so many mistakes and so many, it's just like it's made up. It doesn't make sense.
I think that we did ask that individual, and they stated that they did not use AI. It was regularly told to that person that AI was not to be used to draft the briefs. If there are some mistakes, and we tried to correct the mistakes that we did notice, but AI was not.
Did you, though? Did you really?
Used, at least not to the knowledge of myself or the attorney filing the briefs, that it was used.
So the person who does, I want to be clear what you just said. The person who's doing the drafting is not the person whose name is on the brief that gets filed in the court?
No, but the things that do get filed with the court get reviewed by the attorney.
I noticed that, unless I'm missing something, your name is not on the brief.
No.
Why is that? This fellow works for you?
No. So the individual whose name is on the brief is Mike Sethi. He is the primary attorney in these cases. I work for him.
Is the person who's doing the drafting a lawyer?
No, it has graduated from law school, but is not a lawyer. But that person is.
I just wonder. I would love to see the billing entries for the work this person does.
Is no longer with the office.
They definitely exist, though.
But Mike Sethi is the primary attorney. That's why his name is on all of the briefing.
Did you want to save time for rebuttal?
If I may.
All right, we'll hear from the government.
I think part of the shame of this is it seems like there actually is a real case underneath all of the AI stuff there. He did identify specific errors or at least inconsistencies in the order below. And this is an immigration case. It's not somebody suing somebody else. This is a potential torture case where somebody's trying to seek asylum. And that's not really a good situation to be using AI. Not that there's a good one.
Good morning, Your Honors. May it please the Court. My name is Linda Chang on behalf of the U.S. Attorney General. In today's case, substantial evidence supports the adverse credibility determination for the three reasons discussed in the agency's decision. First, I will also address the fact that Your Honors picked up on this issue of whether the IJ referenced the falsus in uno, falsus in omnibus maxim. There is nothing inherently impermissible about stating this maxim, as it is discretionary ability for the immigration judge to apply it. In this case, the immigration judge did not.
As to material matters, not as to collateral matters, correct?
That's correct. And I think what Your Honor is getting at is in the case that it is cited from Yang versus Lynch, it was an adverse credibility case in merits hearing that was then being applied to a motion to reopen, which is not what's happening in this case. And in any event, the immigration judge did not apply that maxim. As we see, he went through very specific and cogent reasons.
Why did he cite it then? I mean, just for the heck of it?
I'm not sure. This was an oral decision, so I can't.
You think he was thinking about it?
I can't be certain what was in the immigration judge's mind.
I mean, it's pretty
common.
Sometimes being a lawyer is a deeply silly exercise. This is one of those cases. I don't know what he was thinking, man. He said the thing. He said another thing that doesn't make sense with doesn't line up with the first thing. I don't know what he was doing. Oh, that was a really good answer, though. She's very smooth.
Maxim that we use it in trial courts all the time. I mean, I instructed many juries.
It is.
When I was
This
a
is
trial
true.
judge, state and federal.
This is true. And again, there is nothing impermissible about applying this maxim. However, in this case, it was not used. As we see, there are very discrete, cogent reasons that
If it was
support.
used, would there be a problem?
No. Again, it is permissible. However, it was not used in this case.
I understand that that's the government's position, but if we
It does seem a little odd that that's the angle she's taking because, I mean, I haven't looked at the briefs in this case, but it does seem like everybody agrees that the judge specifically referenced this maxim, and now she's arguing that the judge did not use the maxim, apparently only referenced it. I don't know if this is the angle I would take. It seems more sensible to say, he referenced it and, he could have used it, but in practice, what he actually did was something else. He didn't actually use it, rather than just saying, I don't know. So he could have used it. He thought about using it. He used it in the alternative, rather than saying he didn't use it, because that's hard to square with invoking it.
disagree and think that the agency actually did rely on this maxim, then what?
I think we still need to go through the rest of the immigration judge's or the agency's decision to see whether the totality of the circumstances supports an adverse credibility determination. I don't think the analysis would end with just the application of such a maxim, in which it did not happen here.
Can you talk a little bit about, I'm very confused why the agency didn't seem to pick up on the fact that this concern about a duplicate statement and two different declarations seems to be easily explained by the fact that the second one was quoting the first one. And the agency doesn't deal with that explanation that was provided in the administrative proceedings. And so it really does seem that
Again, it does seem like there's a legitimate case here.
the agency is not very carefully looking at this evidence. Tell me why I'm wrong.
The details around that declaration remain that when Petitioner was asked about this duplicate, verbatim statement, he provided the unconvincing explanation that the head of village council wrote it by mistake. We see that on AR 123. However, in the immigration judge's decision itself, he references that he has some concern about these statements, including medical records, because all of these declarations or documents were in large part based on hearsay information provided to them from the respondent. This is on page 25 of the record. So I think that kind of addresses why there was concern about this duplicitous or identical language, even though it is explained away by saying that he might have been referencing the statement by the father.
No, he was referencing. Yes,
can't
not
say
he might
might,
have
he
been.
was.
Right. But nonetheless, it was then provided to him by hearsay information from either respondent or respondent's father, and so then it
Well,
does...
of course it was going to be hearsay because he's quoting someone else. So I'm not quite sure that really explains how the agency addressed the explanation that was given for why there was this issue.
Yeah, if you're quoting somebody else explicitly, that will be hearsay, well, generally.
That the agency was concerned about.
Right. Well, again, I think it goes to the totality of these...
That's not a good answer in this. If you're being asked about a specific instance or a specific error, and you say, oh, well, the totality, you're kind of punting on answering the question.
documents, these declarations that were all notarized and signed on the same day and translated in India, including Petitioner's own, who
There was an explanation for why that they all happened, that they were all notarized together, and I don't see that the agency dealt with that explanation either.
Well, correct. Petitioner provided an explanation, but nonetheless, the agency does not necessarily need to accept his
Well,
explanations.
that's true. They don't have to accept the explanation, but when a cogent explanation is given, don't they have to address why they don't believe it? And I don't see that that was done in this record.
Well, the agency just did not seem to... The agency had concerns about these declarations because of the implausibility of how it was done, including Petitioner's own declaration, which he wrote in Hindi in
Okay, why was it implausible?
America, and then had it sent to India to be translated into English by the same interpreter and notary. It just...
Okay, let's just think about what she just said there. So it's implausible that an Indian native writes something in Hindi and the translator that he chooses to use is in India, which, to my knowledge, is a good place to find somebody fluent in Hindi. I'm not an expert, but that seems very plausible. I mean, I guess you could find somebody, who speaks Hindi in the U.S., but presumably you have connections in India, and there's notary. It kind of makes sense to me.
Had issues that the immigration judge
What are the issues?
kind of found concerning.
What were those issues that he found concerning?
Well, like we've said,
Sorry, I want to hear the way you said that again. That was fun.
kind of found concerning.
What were those issues that he found concerning?
Well, like we've
And again, the judges aren't even really arguing with her so much as just trying to find out what happened exactly. Like with the invocation of the maxim, the government's taking the position that the maxim wasn't used, but it was explicitly referenced in the oral decision. So why? That's not really an argument. That's just a question as to what happened. And again, here, the judge is asking what were the concerns that you say were pertinent. It's not really an argument. It's just hey, what's the deal?
said, this detail goes to why Petitioner left India, and it seems to be only based on his own statements.
Well, yeah, he's the one trying to leave India. Who else is you? Okay.
And then, so that would be based on hearsay to the other declarants. And in this case, it just seemed.
It just did. The petition spoke to me.
Implausible or.
Were there any explanations as to why it was implausible?
Exactly. It's the same question he just asked. What is the issue? Like what is the get down to just answer the question. What happened?
Other than the same statements without recognition that one was a quote of the other. I mean, it didn't seem like he really read these documents very carefully, does it?
I wouldn't go so far as to say that.
But you won't say no.
Then how could he explain the fact that he's making a mistake? These two people aren't saying the same thing. One is quoting the other.
Well, when Petitioner was asked about this specific statement, the reason that he provided, though, was that it was a mistake. So taking that explanation.
So let's just be clear. So the immigration judge fucked up, and then he asked the petitioner a question premised on the fact that the judge had no idea what was going on, and the petitioner's confused, and then said it was a mistake. So you can't, no, if you're incompetent and you just say nonsense to somebody, and then they say something in response that doesn't make sense, you are the one who introduced the nonsense to the equation. You can't throw a bunch of nonsense and then be upset when nonsense comes back your way. That's just, how it goes.
In contrast to what the statement was in the declaration, it seemed like he himself did not know what was in the declaration either.
It's also not his declaration. And you were just criticizing him for hearsay. Now you're criticizing for not knowing the sworn contents of the contents of somebody else's sworn declaration. That's not really consistent either.
Go ahead.
Again, all of these reasons have to be considered in the totality of the circumstances.
What circumstances?
In which case.
Let me ask you this one other question.
Sure.
What's so serious about the discrepancy between worker and member?
That's a good question, Your Honor.
I guess to some extent I'm a member of this court, but I also work for it, I could say I'm a
Sure, it all depends on your own interpretation. And here, petitioner's own testimony, he states that there is a clear distinction. The members provide orders to the workers to execute. So if it were not for his own definition of why they are different, and they are two different categories, there might not be any distinction. But he himself has laid it out as being so in testimony page AR 92. So because he has laid it out as two separate categories, we recognize that he treats it differently.
He also described himself as a volunteer member.
That is correct.
What does that mean?
To the extent that he does.
It's funny. These questions are so simple, and yet they're difficult to answer. I assume the point is that given the definition that the attorney just gave to us, a volunteer, like if you're a volunteer, that kind of implies that you're working on something, right? So that kind of breaks down the distinction between member and worker that she gave.
Say volunteer, we have only honed in on the aspect of whether he was a worker or a member in that context as well. He does not differentiate what a volunteer versus non-volunteer would mean.
Okay.
It's incredibly mundane.
Did the government become aware that there were errors in your opponent's briefing?
Yes, we did in the preparation. In the preparation of this oral argument, more specifically.
You must have been curious about why we set it for argument.
Very much so, Your Honor.
You hadn't noticed it before? Does the government check the brief?
This is something that judges, I've been seeing increasing lately, judges are as harsh on opposing counsel for not catching these mistakes as they are on, not as harsh, but nearly as harsh on opposing counsel who don't catch mistakes like this, as they are on the attorneys who introduce AI or introduce hallucinated cases, and I think that's totally appropriate. It's the same thing. I mean, one's not quite as bad as the other, but they're in the same ballpark.
We do check the briefs, Your Honor. To the extent that these cases did not exist in this section regarding corroboration, we argued that petitioner failed to exhaust the issue of corroboration, and moreover, the agency did not make a specific corroboration finding. So that was not something that we needed to address very specifically. But also to the point of these cases that he corrected, they still don't actually stand for the propositions that he says. And also in looking at the other cases, you've already picked up on several, they don't actually support the statements antecedent to them.
So I guess from your statement, the government didn't realize that until after they filed the statement wanting to correct some of the citations in their brief?
No, we saw it when we were preparing for arguments, so it was prior to that Friday when the motion was filed.
Does the government have a practice of alerting the court when there are concerns like that, or no?
We were concerned. However, there is no mechanism for us to alert the court to a miscitation. It would not necessarily be a 28J, and further, we're not sure how to categorize it to the court without having just accusations lodged.
Fair enough. Okay.
So if Your Honors don't have any other questions, for the reasons cited in our brief, and today we think the court should deny the petition for review. Thank you.
All right, Mr. Rounds, you have a couple minutes.
She did well. I don't necessarily believe for the argument itself, but she handled it well.
Put 2 minutes on the clock.
This is the part that really irritated me. Listen to what he chooses to spend his 2 minutes on. Who is he protecting? Whose interests are we looking out for in these 2 minutes that are about to follow?
The petitioners did attempt to correct the errors.
Cover your ass. Somebody else's life is on the line, and you're choosing to protect yourself.
That they saw. There was no indication to us that there was any kind of AI tool used.
Well, if you read the brief, you would know. So there was an indication.
We had asked about it and advised or instructed on it many times not to be used.
Well, if you had read the cases that you cited, you would have known that
Excellent point, Your Honor.
the phrases that were attributed to those cases didn't exist. Doesn't it sort of indicate that somebody snuck something in?
I love this guy.
That the phrases that were attributed to those cases didn't exist. Doesn't it sort of indicate that somebody snuck something in?
It appeared to me to be that the holding was from a different one of the cases that we cited in some of those instances.
Right, so it wasn't in the case you cited, and it was a very good argumentative case. I mean, the citation was, this is a death knell. I mean, that's a pretty strong argument, isn't it? And it just didn't occur in the case, and you didn't catch that, did you?
No, I did not catch that.
Right.
It did occur in at least one of the cases. I believe it was Shrestha, and I think another case also used that.
Again, he's still just trying to cover himself. He's not even like looking out for his client here. That's disgusting.
Exact same language. Both of those cases we did cite, but I did not catch that the case that was cited for that language was not the case that was included at the citation.
So as I understand it, you have a non-lawyer drafting an agreement or drafting a brief that you don't site check the cases yourself to see that the language is in there, and your boss doesn't either, right?
It sounds not on every occasion.
Sorry. I need to hear that again.
That was included at the citation.
So as I understand it, you have a non-lawyer drafting an agreement or drafting a brief that you don't site check the cases yourself to see that the language is in there, and your boss doesn't either, right?
It sounds not on every occasion.
I'm sorry, what did you just say?
It sounds like not on every occasion.
It sounds like.
Yes, because some of those things got through. Although it is.
Just own it. Like, seriously.
Regularly checked for things that appear controversial, but in some cases.
Again, what has he said for his client in these 2 minutes?
It didn't seem like it was controversial. In this particular case, I'm not sure, but that is the pattern and practice, the habit.
No, you are sure, though. You know, because you know what happens based on what's just happened in the past half hour.
Practice. But notwithstanding some.
Is this fellow a member of the bar now?
No. The individual
fellow
drafting.
who wrote the brief?
No. So notwithstanding some of those errors, which we attempted to correct as much as we could, I think that the law is still on the petitioner's side in this case. Thank you.
All right.
Okay.
The matter of LNU versus Bondi is submitted.
So, yeah, that is a mess. I think what really bothered me was the second part. When I watched this originally, that's what got my attention. The fact that in the last 2 minutes of rebuttal, he had the opportunity to advocate for his client or advocate for himself. And he chose to advocate for himself for no real reason. He still wasn't really being honest with the court, and the court clearly knew that he wasn't being honest and forthcoming, which only further antagonizes the court. And I don't think that they're going to take it out on the client because they're clearly upset with the lawyer for not representing his client well. But I mean, still, this guy totally dropped the ball. I don't know, he never really picked up the ball, but if he had, he would have dropped it. But yeah, completely unacceptable. It was fun to see him get roasted, though, so at least we have that as an upside. But yeah, that is that. Hope you found that interesting. If there's interest, I'll do some more of these AI videos because there's certainly no shortage of cases. All right. Thanks for watching, everybody.